Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. Okay, so we're going to start going through that huge document drop that was dropped in the Idaho 4 case this past Friday. I've kind of taken just a few days because I know that I'm about to be doing this for probably the next 4 or 5 days in a row, like nonstop. So I didn't post anything yesterday. I just sort of was a viewer of all platforms yesterday and just didn't want to post literally anything. But we're going to start going through these. I am going to do it per document because I have, like I've mentioned, an over 4-hour long video where I went in and read the defense's documents when it comes to them trying to get rid of the death penalty, the aggravators, and all the things they're arguing right now. So this first one is going to be the trifurcation documentation. Now I say this first one, but in reality, we've actually gone over 2 different documents. We've gone over where the state has now removed the burglary aggravator, or the 4th aggravator on their list for why they want the death penalty. They're doubling down on wanting the death penalty, but with 4 factors instead of 5. If you missed that video, this is what the thumbnail looks like. And then we also went over the document where they're basically telling you step-by-step instructions on how to request sealed documentation. I did fill out a form. I did send it off. I have not received a response as of yet, but I honestly don't expect any of these to be approved. That would literally completely defeat the purpose of the last almost 2 years worth of gag order arguments. So again, I don't know why that document was posted, but if you missed that one, this is what that thumbnail looks like. Now, the state is objecting everything except for the one thing that we talked about in the last video. This states, comes now the state of Idaho by and through the Latell County prosecuting attorney and hereby objects to defendant's motion to trifurcate proceedings and apply rules of evidence during the eligibility phase. For the following reasons, the court should deny defendant's motion. Analysis. In his motion, defendant disregards applicable statutory authority and binding appellate decisions and instead makes a public policy argument that this court should do 2 things. First, he asks that this court to disregard the language of Idaho Code 192515, which sets forth a 2-part jury proceedings in capital cases. Under the defendant's proposed scheme, the trial would not be composed of a culpability phase and a sentencing phase as set forth by statute, but would instead be split into 3 proceedings for culpability, eligibility, and punishment. Next, defendant asks the court to disregard long-settled precedent holding that the Idaho rules of evidence do not apply to sentencing proceedings and to apply them anyway. The court should decline to do either. A. Idaho Code 192515 provides for a single sentencing proceeding in capital cases. Idaho Code 192515 sets forth the procedure for sentencing in capital cases and calls for a single sentencing proceeding. Throughout 192515, the code refers to a special sentencing proceeding or the special sentencing proceeding, clearly delineating a single hearing for the jury to determine whether capital punishment is appropriate. I see 192515 and there is a footnote and it reads, similarly, all of the criminal jury instructions set forth by the Idaho Supreme Court contemplate a single sentencing proceeding in capital cases. If the defendant is convicted of murder in the first degree, there will be a separate sentencing phase of the trial. The defendant in this case has been convicted of the crime of first-degree murder. We will now have a sentencing phase of the trial regarding that offense. In determining the facts, you may consider only the evidence admitted during the trial and during the sentencing phase. The state has the burden of proving the existence of a statutory aggravating circumstance, and that burden remains on the state throughout the sentencing phase. And it also states to see the Idaho criminal jury instructions, the 1700 death penalty sentencing instructions, which is available right here. Let's see if it goes. Yeah. Oh, look at this. They just updated the death penalty criminal jury instructions after all that argument that they did. And that's actually really interesting because the defense argued the jury instruction, And it even went up to the like Supreme Court, and the Supreme Court denied it, but then they ended up changing stuff anyway. I'm not going to sit here and read all of this right now, but it's there. Look at all this stuff that's scratched out. Links, as always, will be in the description box. All right, it continues right here and says, it is therefore unsurprising that in Idaho, capital cases have generally followed the two-part procedural outlined by the statute. And then it lists State versus Hall, State versus Dunlap, Civic versus State, State versus Creech. Creech is the one that they just like unsuccessfully tried to execute the guy, and they're about to start it again. And the date that I'm seeing for the next execution attempt is November 13th, which is just wild to me, but okay. In an attempt to bolster his request that this court ignore Idaho's statutory procedure for capital sentencing, defendant claims that the United States Supreme Court's decision in Ring versus Arizona renders a bifurcated model of sentencing especially problematic, and further asserts the Ring court found that statutory aggravators are elements of the offense of capital murder. And then it talks about a memorandum of the defense's memorandum in support of trifurcation is what they're referencing in this one too, because they're talking about a case that the defense referenced in their argument. That is not at all what the Ring court held. The Ring court's holding applied to a statutory scheme which allowed a jury to convict an individual of felony murder without determining whether the defendant was the actual killer, and then allowed a judge to make the factual finding that the defendant was the killer in order to determine whether to impose the death penalty. What did I just read? Let me reread that, because it sounds like they literally just said that they could put somebody as the felony murderer without determining whether they're the actual killer or not. And that doesn't make any freaking sense whatsoever. That is back-asswards as shit. Let's reread, okay? The Ring court's holding applied to a statutory scheme which allowed a jury to convict an individual of felony murder without determining whether the defendant was the actual killer. What? And then allowed a judge to make the factual finding that the defendant was the killer in order to determine whether to impose the death penalty. So, guys, I'm not stupid. I promise I'm not stupid. But am I hearing this? Am I hearing this? That they can have a jury convict someone of felony murder without them having to prove or even like have it in their brains that that person is the actual murderer, just so the judge can impose the death penalty on them? Even though they don't have to prove they're actually the killer, the actual factual murderer? That's how I read that, guys. So if I'm wrong, let me know in the comments. If you agree with me, let me know in the comments. In general, let me know in the comments what you think about that statement, because it's right there in black and white, and that's wild. Wild. And this is the Ring versus Arizona case that they're claiming the defense used in their argument. So yeah, that's even more crazy. Far from holding that statutory aggravators are elements of the offense of capital murder, the Ring court held that because Arizona's enumerated aggravating factors operated as the functional equivalent of an element of a greater offense, the Sixth Amendment requires that they be found by a jury. 2 years later, in Skyro versus Summerlin, when analyzing a separate issue, the United States Supreme Court reiterated that Ring's holding was entirely based on the right to a jury trial. Ring held that a sentencing judge sitting without a jury may not find an aggravating circumstance necessary for imposition of the death penalty. So if there's a judge with no jury, they can say, yes, this is a death penalty case, even without the aggravating factors. That's wild. Rather, the Sixth Amendment requires that those circumstances be found by a jury. So a jury has to find those aggravating circumstances, but a judge doesn't? This is why I couldn't be a lawyer, bro. This stuff is bullshit. This holding did not alter the range of conduct Arizona law subjected to the death penalty. It could not have. It rested entirely on the Sixth Amendment's jury trial guarantee, a provision that has nothing to do with the range of conduct a state may criminalize. That looks to have been from Shiro versus Summerlin from 2004, which they've already referenced that one more than once. In State versus Abdullah, the Idaho Supreme Court rejected an argument similar to the one the defendant makes in his motion. The Abdullah defendant argued that under Ring, death penalty aggravators should be filed with an indictment or information, asserted that Ring transformed the aggravating circumstances into elements of the charged offenses. The Idaho Supreme Court soundly rejected this contention, holding that Ring did not transform the functional equivalent elements of aggravating circumstances to the level of actual elements of an offense to require the state to allege the aggravating circumstances in the indictment or information. How are you going to sit here and say that a person that is one-minded, that doesn't have to be double-checked to make sure that they see all the evidence, they've heard all the evidence, how does that person get the ability and the authority to impose the death penalty without having to prove all of these certain aggravating factors that are necessary for a jury to prove? But a jury that has multiple people, multiple brains thinking about the same outcome, they have to prove all of these things are there first? That just sounds like it doesn't... Who wrote that? Who wrote that back-asswards law? That's wild to me. The court also explained that without the designation of aggravating circumstances as elements of a crime, the state's formal notification of the intent to seek the death penalty does not carry the constitutional requirements of an indictment or information. Citing to its earlier holding in State versus Porter, the Abdullah court reiterated it had stated in clear terms that the statutory aggravating circumstances are not elements of a crime. Shouldn't they have to be? Shouldn't they have to be? The defendants claim that Ring stands for the proposition that statutory aggravators are elements of the offense of capital murder is wholly unsupported by Ring itself, as well as Idaho Supreme Court cases that followed it. Another problem with defendant's proposal to trifurcate proceedings is his lack of clarity as to how, as a practical matter, the presentation of aggravating and mitigating evidence would play out. Defendant asserts the eligibility phase is akin to a guilt phase in that the state bears the burden of presenting evidence supporting each statutory aggravator it seeks to prove, as it should. Thus, under the defendant's proposed model, statutory aggravating evidence would be introduced and admitted during the second of three phases. Later in his brief, defendant asserts the third phase, the sentencing phase, in which the jury determines whether death is the appropriate punishment, would be conducted like a regular sentencing proceeding in which the rules of evidence are not applied and other rights, including the right to confrontation, are limited. All the evidence in aggravation that the state seeks to introduce is admitted in the final phase for the purpose of determining an appropriate sentence. Defendant goes on to explain that mitigation evidence would not be heard until the final phase of the trifurcated proceedings, proposing, in contrast to the eligibility phase, the sentencing phase, in which the jury decides whether the death penalty is appropriate, is more like a non-capital sentencing determination. At this phase, it is the defendant's burden to present mitigating evidence and the sentencer's role to decide the appropriate punishment. Unlike evidence of statutory aggravation, which must be provided beyond a reasonable doubt, mitigation does not need to meet this burden. The jury does not need to find that mitigation outweighs the aggravation beyond a reasonable doubt. The jury considers both statutory and non-statutory aggravation when making this determination. Thus, under the defendant's proposed model, the jurors apparently would render a decision on whether or not the defendant is death eligible after hearing the state present statutory aggravators without hearing mitigation evidence from the defendant. In Lockett versus Ohio, the United States Supreme Court held that a capital defendant has the constitutional right to present mitigation evidence during sentencing proceedings. The court held that the 8th and 14th Amendments require that the sentencer, in all but the rarest kind of capital case, not be precluded from considering as a mitigating factor any aspect of a defendant's character or record and any of the circumstances of the offense that the defendant proffers as a basis for a sentence less than death. I am like, my eyes just went ahead and read the next sentence, and I'm agreeing with the state here. I'm agreeing with the state because if Bryan Kohberger's team is wanting to hand over all of the mitigation work after the death penalty eligibility is determined. I mean, yeah, I feel like that's backwards too, because isn't the whole point of mitigation, if Bryan is found guilty, isn't the whole point of mitigation to like help the sentencing? Because there could be some sort of mental abuse, there could be some sort of abuse in his past, there could be all these things that end up popping up as excuses that they like to use. Okay, let's just admit what they are. They're excuses. Okay, sometimes they're valid, 99.9% of the time they're not. But wouldn't that be something that gets put ahead of it being death eligible? Because if there's factors that would make it to where, oh, well, instead of death because of X, Y, and Z, this is what we need to do instead, and it lowers the severity of the punishment, why would he want to present that after the fact? I agree with the state here that does seem like it's a bit backwards. So let's see if I continue to agree. It is difficult to see how the model proposed by defendant would benefit him in this case, where one of the statutory aggravators arises from Idaho Code 19-25159I, which looks to whether the defendant, by his conduct, whether such conduct was before, during, or after the commission of the murder at hand, has exhibited a propensity to commit murder, which will probably constitute a continuing threat to society. That's the last aggravator, and they kept that one in there. As I mentioned, we read through those in the last video. It defies common sense to believe that defendant would benefit from a trifurcated proceeding where the jurors would consider whether he poses a risk of future dangerousness and is therefore eligible for the death penalty without hearing all of the mitigation evidence relevant to that aggravator. Yeah, it does sound backwards. Though not binding on this court, the potential unintended consequences of adopting defendant's proposed model were recently highlighted by post-conviction counsel for the defendant in State versus Renfro, which to the state's knowledge is the only capital case in Idaho where a court chose to adopt a trifurcating proceeding. So it's the only one. So Anne is kind of just like taking stuff that has happened every now and then and seeing if it'll go through, I'm guessing, which is basically what they do, right? They find other cases where certain things have been successful and then they try to use them to their advantage. That's why they have so many cited in all of these documents. And again, this is Renfro versus State, and it looks like this amended petition for post-conviction relief that they're citing this from is from 2019. In that case, defense counsel moved for a trifurcated proceeding based on nearly identical arguments, motion and memorandum in support of motion to trifurcate proceedings, and that's the document from State versus Renfro, and they claim that it's pretty similar. So I'm almost wondering if copy and paste, which I'm pretty sure they can if they feel like their arguments are valid to their situation, but I'm wondering how that looks like plagiarism wise. I don't know how that works in the law world. But they're also mentioning a document that was posted in 2017 for this one. However, in a subsequent petition for post-conviction relief, post-conviction counsel argued trial counsel's request for a trifurcated proceeding constituted ineffective assistance of counsel. While trifurcation can, in theory, benefit a capital defendant, it also carries substantial risks of overemphasizing and front-loading negative aggravating evidence without a concomitant emphasis. I have never in my life seen that word. Concomitant. Okay. Emphasis on mitigating evidence if not properly implemented. Simply put, trifurcation is a means to an end, not an end. And this is again coming from that post-conviction relief from the Renfro versus State case. The court should decline to deviate from the procedures described in Idaho Code 19-2515 based on a reading of Ring that is wholly inconsistent with the United States Supreme Court's own reading of that case. So that just sounds like, and it does sound like it to me too, by the way that the state's describing it, is that the defense like misinterpreted or misunderstood what is being said and done in that Ring case is what it sounds like. B. It is well settled that the rules of evidence do not apply to sentencing proceedings. As the defendant straightforwardly acknowledges in his brief, the Idaho Supreme Court has held that the rules of evidence do not apply in capital sentencing proceedings. Defendant also acknowledges that the Idaho Supreme Court has also held that the right to confrontation does not apply to sentencing procedures. The defendant is correct. Idaho appellate courts have repeatedly held that the Idaho rules of evidence do not apply to sentencing proceedings. And they again cite State versus Hall, State versus Dunlap, State versus Creech. Similarly, Idaho's courts of appeals have also held that the Confrontation Clause does not apply to sentencing proceedings. And then it goes to talk about Dunlap again. After a lengthy and scholarly consideration of precedent from the U.S. Supreme Court, that court concluded that the Confrontation Clause is inapplicable to the presentation of testimony relevant only the sentencing authority's selection decision. We agree and hold the admission of the reports did not violate Dunlap's Sixth Amendment right. And now we go on to Civic versus State, where they are citing, we continue to adhere to our ruling in Creech and the position of the United States Supreme Court that the Sixth Amendment to the United States Constitution does not require that a capital defendant be afforded the opportunity to confront and cross-examine live witnesses at his sentencing proceedings. Okay, I wanted to get a little bit more information on what a confrontation clause actually is, because what I'm reading makes it sound as if the defendant is not allowed to cross-examine the witnesses that are coming before him to accuse him, and that doesn't make sense to me because I thought that that was like a constitutional right to do so. So I looked up confrontation clause. This is the Cornell Law School Legal Information Institute website, and it states the following. Confrontation clause refers to the provision in the Sixth Amendment of the U.S. Constitution that in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. Confrontation means that in a criminal proceeding, the defendant has the opportunity to face the witness and cross-examine them to object to the testimony. Under the 14th Amendment, the right to confrontation applies not only to the federal government, but also to the states. It is designed to prevent a defendant from being convicted based on written evidence without having the opportunity to face their accuser and test their honesty and truthfulness before a jury. And let's also see right to confront a witness. Right to confront a witness. The right to confront a witness is one of the fundamental constitutional rights that protects the citizens of the United States. The Sixth Amendment of the United States Constitution states that any criminal defendant suspected of committing a crime has the right to confront the witness in a criminal action. The right to confront a witness entails the right to be presented at the trial and the right to cross-examine the witnesses presented by the prosecutor. So, just for the sentencing phase? Not during like the evidentiary stuff where they show all the evidence. This is after the fact during the sentencing phase. But doesn't the defense still talk to people in the sentencing phase? Like, don't they still cross-examine them when they become like witnesses for sentencing? Because isn't that where like the Goncalveses are going to have to come up and talk? Like, if Bryan is found guilty and we get to this portion of it, isn't that where the whole like, oh, they're witnesses, boo-boo came in? Pretty sure. And I just don't see a world where the defense isn't going to ask Steve Goncalves a bunch of questions. I just don't. Okay, let's finish up this document. Nevertheless, defendant asks this court to disregard the holdings of the Idaho Supreme Court and instead be guided by the authors of various law review articles, but this court cannot do that. As the Idaho Supreme Court explained in State versus Guzman, to this court falls the obligation to be and remain the ultimate authority in fashioning, declaring, amending, and discarding rules, principles, and doctrines of precedential law by application of which the lower courts will fashion their decisions. This court has been and remains the final arbiter of Idaho rules of law, both those promulgated and those evolving decisionally. State versus Guzman again in 1992, and it states the court should reject the defendant's request to override Idaho's courts of appeal and deny his motion. Conclusion. The defendant asked the court to disregard the plain language within the Idaho Code 192515 and the ambiguous holdings of the United States Supreme Court and the Idaho Supreme Court. He urges the court to ignore the procedures set forth and upheld by binding legal authority and instead impose procedures based on public policy arguments. His motion should be denied. Well, I guess that's it. It looks like they've only ever done like a 3-sectioned proceeding once in Idaho's complete history, according to this document. It's not a normal procedure. And I agree with the state with what they said about the mitigation stuff happening after the sentencing phase. That seems really backwards. It doesn't make a lot of sense to me, but I'm curious as to why the defense wants to do it that way. I guess maybe I didn't catch it whenever I was reading it, or maybe I'm just not knowledgeable enough in the terms to understand that that's what the defense was trying to say, that they wanted to do it a little bit backwards. But if that's the case, then yeah, that doesn't really make a lot of sense to me. It really just doesn't. And I am also like really confused on the whole, can he cross-examine or can he not cross-examine the witnesses? But I think it's just because they were talking about the sentencing phase. And I mean, at that point, all of the evidence is out there. Whatever the witnesses are going to say is it. I really do think that that's something that like I mentioned, is more towards the Goncalveses because it's the sentencing portion of it. But I don't know. I don't know if they're going to end up changing things up because this is like a really high profile case, or if they're going to keep things the way that they are. But it does sound like the whole trifurcation thing has only happened once, like in the entire state. So we'll see what Judge Hippler decides to do. I don't know when they're going to have any answers on any of this stuff. Hopefully I get all the documentation out before we start getting answers, or else that's going to be like a real big headache, but we'll get through it if that's what happens. But let me know what you guys think down in the comments about this set of documents. If you like the way that I present this information and give my opinion, please don't forget to leave a like on your way out. Subscribe to the channel if you are not subscribed already, and don't forget to make sure that your notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.